Hello, everyone, and welcome to today's program, Counseling Beyond the Law, The Rise of Business Therapy. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speaker, Talin Yacoubian. Talin is a partner and founding member of Yacoubian Powell, LLP. She has over 3 decades of experience in environmental litigation, business law, and dispute resolution. She held an instrumental role in the Iron Mountain Mine Superfund settlement, one of the largest environmental settlements for federal and state agencies in California. Talin represents clients across a broad range of matters, from renewable energy and intellectual property to civil rights and construction, and serves as general counsel to an international conglomerate. Beyond her legal practice, Talin is deeply committed to public service and her community, having organized the 2015 Armenian Genocide Centennial March of 160,000 people in Los Angeles. She currently teaches legal writing and advocacy at USC Gould School of Law. We're so excited to hear what she has to share with us today. Please submit your questions in the Q&A box below. And now I'm going to turn it over to her.
All right. Thank you very much, Ella. I appreciate that introduction. Again, just to recap, I'm Talin Yacoubian. I'm a civil litigator and mediator. I'm based in downtown Los Angeles. Thank you for being here today. My plan is to keep you interested for the next hour or so, and then we can look at the Q&A for questions at the end. And I really encourage you to ask questions. I'm excited to talk about this and excited to answer your questions from your lens. Because this is just all me right now. A little more about my practice. My practice spans civil litigation and mediation. I do business and commercial matters, IP, employment, environmental, and a lot of real estate. I've represented individuals, small businesses, large companies, public entities. I've been in courtrooms, deposition rooms, and conference rooms trying to hold a deal together until all hours of the night. I've spent the last several years building a mediation practice alongside the litigation work, which means I've now sat on every side of the table as an advocate, as a neutral, and sometimes as the person in the room who's just trying to figure out what the two sides want from each other. So what I want to share with you today is a framework that has come out of all of that. 33 years of watching what actually works and being honest with myself about what doesn't. By the end of this hour, you'll have a concrete set of tools that you can take back to your own practice and use right away, hopefully. Not theory, not soft skill seminars, just really practical tools that'll make you more effective with the clients who are hardest to help. As I've said, I've been practicing for several decades, long enough to know that the cases that stay with you aren't always the biggest ones. Sometimes it's a conversation. Sometimes it's a single sentence that lands a way that you weren't expecting. A few years ago, I had a client who was herself a lawyer, which, as many of you know, who have represented lawyers, comes with its own particular dynamic. She was going through something difficult, a personal dispute that had crossed over into litigation, and she was handling the underlying matter herself, but she brought it to me because she felt overwhelmed. She was just too close to the matter. At some point during one of our calls, she broke down. She was crying, like really crying, and I'll be honest, it was uncomfortable for both of us, even over the phone. There's something particularly disorienting about having a fellow attorney fall apart. We're trained to hold it together. We're trained to be the ones who hold it together for other people. And here we both were. I did what I could. I didn't try to fix it. I just let her be, in the moment. And eventually, the conversation found its footing again. Then, a few days later, she called me back. Just a regular check-in, and almost as an aside, like she'd been quietly turning it over in her head, she said, you don't just practice the law, you also do business therapy. The phrase just really struck me. I wrote it on a Post-it and I stuck it on my computer screen. And I just kept looking at it. And I just started thinking about it all the time. Started seeing it everywhere. I'd be in the middle of a client meeting, walking through strategy, and I'd realize the legal question isn't really what's driving this conversation. What's driving it is fear or grief or a pattern this person has been repeating for 20 years and doesn't know it yet. I started going back through the years of client work in my head, things clients had said, moments where something shifted in a meeting, representations that went usually well or unusually sideways. And what I kept noticing was how much of it had nothing to do with the law, at least not directly. It was about trying to understand each person's particular circumstances, what drove them, what they were afraid of, what they actually wanted underneath what they said they wanted. Eventually, I wrote an article about it for the Daily Journal. And that article is what led to today. The article was called How Business Therapy Helps Lawyers Solve What Clients Don't See. Writing it forced me to do something I hadn't done before, to take something I had been intuitively for decades doing and try to articulate it, to give it structure, to explain not just what it was, but why it worked. That process of putting it into words changed how I thought about it. It made me more deliberate, more teachable. And the response to the article told me that I wasn't alone in recognizing it, that a lot of practitioners, a lot of you probably out there, had been doing some version of this without ever really having a name for it. That's what today is. It's an attempt to take what that client identified, what that article tried to capture, and turn it into something that you can actually use, a framework, a set of tools, and enough real world illustration that you can walk out of here and recognize the moment that you need it. So, what is business therapy? It's not a formal credential. You won't find it in any law school classes. It does not require a clinical license. What it is a way of practicing law that takes seriously everything the client brings into the room, not just the legal problem, but the whole context around it, their history, their fears, the patterns they can't see themselves because they're just too close to it. So my goal for the next hour is to give you a framework for what that looks like and some concrete tools that you can start using right away. Before I go any further, I want to be clear about what this is not. This is not about playing amateur psychologist or psychiatrist. It's not about venturing into territory that requires a different kind of license. It's about being a better lawyer, a more effective one, and yes, a more compassionate one, by understanding the full context your client is operating in. All right, let's start with what clients actually bring into your office. Nobody hires a litigator because things are going well. By the time someone ends up in your office, something has already gone wrong. The legal problem is real. But underneath it, almost always, is something messier. I've come to think of every client matter, especially complex, high-stakes matters, as having 3 layers. Layer 1, the legal problem. This is the one you are trained to handle. There's a contract dispute, an employment claim, a partnership that fell apart, a piece of real estate somebody is fighting over. You know how to do this. This is the easy part, and if not easy, at least it's the familiar part. Layer 2, the emotional experience. The client is not experiencing this matter the way it looks in a complaint or in a demand letter. They're afraid. They're angry. They feel betrayed. They're embarrassed things have gone this far. They're worried about what their employees think, or their family, or their business partner, who they still have to see at industry or community events, or maybe even still at their own office. Most lawyers address this layer adequately enough. You listen, you validate, you move on. That's fine as far as it goes. But here's the problem. If the emotional noise is loud enough, It will drown out your legal advice. The client who hasn't been heard won't be able to hear you back. I want to pause on that for a second because I think it's underappreciated. When a client is in genuine distress, and I mean not just annoyed, we've all had annoyed clients. No, something beyond that. When they're really frightened or angry or grieving, their cognitive bandwidth is compromised. Research on this is pretty clear. You can give them the most precise, well-reasoned legal analysis in the world, and they will absorb maybe 30% of it. The rest gets lost in the noise. We've all been there, right? Someone is speaking, but nothing is landing, especially after a long day. Maybe your partner's talking to you, maybe your children are talking to you. It's just not coming through. So addressing the emotional layer isn't a soft skill or a courtesy. It's a precondition for doing your job effectively. Layer 3 is what I call the blind spot. This is the one almost nobody addresses. And it's the one that matters the most for long-term client relationship and honestly for the quality of the outcome. Every client who ends up in your office has, somewhere in their history, a pattern, a behavior, a habit, an avoidance strategy that contributed to the problem they're now sitting in front of you with. The founder who never put anything in writing because she didn't want to make things weird with her business partner. The executive who knew his employment contract had a bad non-compete, but kept telling himself he'd deal with it later. The landlord who ignored 3 early warning signs from his tenant because he didn't want conflict. The legal problem is the symptom. The blind spot is the diagnosis. I had a client years ago who had built a business from nothing, absolutely nothing. A remarkable story, genuinely. But the business had grown so fast that he had never stopped to build it correctly. No real employment agreements, vendor contracts on handshakes, equity arrangements that existed in his head and in emails and nowhere else. Every month, the revenue went up. And every month, the legal exposure went up right alongside it. And he couldn't see it because he was sprinting. What I had to help him understand was that the very thing he was most proud of, the speed, the growth, the momentum, was the thing that was going to take his business down if he didn't stop and address it. He was so focused on building that he couldn't see he was also building the risk. As we all know, an ounce of prevention is worth a pound of cure. In his case, it was worth about 10 pounds. Thankfully, he did a complete 180, and I mean that literally. Today, he sends me almost everything before he signs it, before he commits, before he shakes hands on something new. The blind spot, once he could see it, became the thing he was most vigilant about. That's what addressing layer 3 can produce. Not just a better outcome in the immediate matter, a different client on the other side of it. So business therapy is the practice of helping clients see that pattern gently, clearly, and most importantly, without judgment. While also, of course, solving the immediate legal problem. That's still our job. We have to do that. Now, I want to say something about why this layer almost gets no love or very little attention. It's not because lawyers don't notice it. We do. Most experienced practitioners do notice it. You can see it in the intake. You can hear it in the way a client tells their story. The reason it doesn't get addressed is that it feels a little like it's outside our lane. We're not therapists. We don't want to overstep. And frankly, it can feel like a little bit of a detour when there's a problem, legal problem on the table that needs solving, that needs immediate attention. But here's the cost of skipping it. The client who doesn't understand their own pattern will often make decisions that undermine their legal position. So really take a moment to review that in your own mind. The client who doesn't understand their own pattern will often make decisions that undermine their legal position. Why? Because they're reacting from the same blind spot that got them there. The client who avoids conflict, for example, will agree to a settlement that they can't live with just to make the process stop. How many of you know exactly what I'm talking about? I'm sure many. The client who needs to feel heard will keep escalating. Discovery disputes, motion demands, calls to be more aggressive, more assertive. Not because strategy requires it, but because they don't feel like anyone is actually on their side, fighting for them. Again, I'm sure many of you can relate to this. When you address layer 3, you don't just help the client. You make your own job easier. You make the representation cleaner. You help yourself. The case becomes easier to manage and more likely to produce an outcome that everyone can live with. Now, why does this matter to you as their lawyer beyond just this case? 2 reasons. First, clients who understand their own patterns are easier to advise. They're more likely to follow your guidance. They're less likely to make the same mistake again, which means they're also less likely to end up back in your office in another crisis. Second, and I say this practically, the lawyers who do this well are the ones clients remember. Not just, my lawyer got me a good result. The ones who say, she helped me, he helped me understand my business in a way I hadn't before. That's client retention. So, moving on, what does this actually look like in practice? I'm going to give you 5 tools. We can move to the next slide. The intake question nobody asks. 5 tools. Excellent. Most attorneys start an initial consultation by asking, tell me what happened. I've said it, you've said it, and that's fine. But there's a question that is asked less often, and it opens everything up. What do you think you want to happen at the end of this? Not what are you asking for legally, not what does the contract say you're entitled to. What do you actually want at the end of this? I can't tell you how many times the answer to that question has completely changed the shape of my representation. Clients come in asking for full litigation, and they actually want an apology. They come asking for a settlement, and they actually want their day in court. They say they want money, and they actually want the other side to be held accountable publicly. When you know what winning actually looks like for your client, you can give them advice that is actually aligned with their goals, not just technically correct. Let me give you a concrete example. I had a client in a defamation matter, real damage, professional reputation, relationships, kind of thing that follows you. He came in ready to litigate. He wanted damages. He had a number in his head. And I asked him early, before we had gone too far down the road, what do you actually want at the end of this? He was quiet for a moment, and then he said, I want them to admit they were wrong. I want an apology. He went a step further. He told me he would take less money if he got an apology. That one sentence completely changed the shape of the representation, because an apology is something that you can negotiate for. It's something a motivated defendant can actually give you. It is not something a jury can award. If I had never asked that question, if I had just taken his stated position and built a damage case around it, I might have gotten him a number. I probably would not have gotten him what he actually wanted and needed. The question cost me 30 seconds. The answer was worth the entire case. And here's the other thing that the question does. It slows the intake down. It signals to the client that you're interested in more than the cause of action. That signal matters. It opens a different conversation. Just as an aside here about the intake, I also wanted to add that try not to take your cell phones in with you when you're doing the initial meeting with the client. That is going to signal that they are the focus, your 100% focus, that you are not distracted by anything else. And that attention, that detail really matters. So, tool number 2, addressing the emotional layer first. Here's the practical truth. If your client walks into the initial meeting frightened and angry, your legal analysis is not going to land. Not because it's wrong, because they're not in a position to receive it yet. So before you get to strategy, you spend 5 minutes, really just 5 minutes, doing nothing but listening. Not problem solving in your head, not advising, not asking questions, not taking notes. Just walk me through what happened from your perspective. Let them finish. I know it's really hard. I know your mind is racing with your questions, with legal theories, with the timeline. You're already trying to construct in your head. Try to sit on your hands. Think about what you tell witnesses when you prep them for deposition. Active listening. Don't interrupt. Let the other person complete their thought. Apply all of that advice to yourself in that moment. Then reflect back what you heard. Not the facts, but the experience. It sounds like what's been most difficult is the feeling of being taken advantage of by someone you trusted. Not how many of you have had partnership disputes between best friends, between family members. Heartbreakingly, this happens so much. Sounds like what's underneath this is real concern about whether the business survives, right? That reflection does 2 things. It makes the client feel genuinely understood, and it clears enough emotional space that they can actually engage with the strategy conversation that follows. So 5 minutes, that's the investment. And the return on it is a client who actually hears you for the next 55. Third, the pattern question. This one takes a little bit more confidence, but it's most powerful. Once you have a clear picture of the matter and the relationship is established, you ask something like, has anything like this come up before? Not necessarily this exact situation, but this kind of dynamic. Or something like, looking back, what do you think was the earliest sign that this was heading somewhere difficult? How often have we found during discovery all of the red flags which telegraph things were headed south? Quite often. These questions at the outset invite the client to see their own pattern without you having to diagnose it for them. And clients who arrive at their own insight are much more open to changing their behavior going forward than clients who feel lectured. I want to be clear. You're not looking for psychological history here. You're not asking them to lie on a couch and tell you about their childhood. You're asking a specific forward-looking question about this matter and this dynamic. The answer tells you a lot about what you're actually working with and what kind of client that you're working with. So the fourth tool is the reframing move. Sometimes clients come in with a stated goal that is not actually in their best interest. Shocking, right? The classic is, I want to go to trial. And sometimes that's the right move. But sometimes what's underneath it is, I want the other side to feel the consequences, or I want to feel like I fought back, or I don't want to be taken advantage of. I've even heard, I want to be able to look my children in the eye to be an example for them. When you can surface the underlying goal, you can often find a strategy that achieves it without the cost and risk of full litigation. That's not steering the client, that's serving the client. Question I use is, help me understand. If we achieve that, what does that give you? And then you listen. The answer to that question often reveals the goal, the real goal. And the real goal is often more achievable than the stated starting position. Number 5 is the slowdown move. This one doesn't get talked about enough. Sometimes the most important thing you can do in an initial consultation is resist the pull toward immediate action. And I know this is hard. They've come in to your office because they need action and they want it right away. The client is in distress, wants you to do something. They want to file, they want to send a letter. They want to put the other side on notice immediately, that very day. And sometimes, again, that's exactly what you will be doing. But sometimes it's driven entirely by the emotional layer, by need to feel like they're fighting back. And acting on it before you've assessed the situation clearly can damage that client's position. The slowdown move is simply naming that. I hear that you want to move quickly, and I want to help you do that. But I want to make sure that when we move in the right direction. Can we take the next week to get the full picture before we decide on our first step? Most clients, when they feel heard, can tolerate a week. What they can't tolerate is feeling like nothing is happening and no one is paying attention. So the slowdown move works best when you pair it with a concrete next step, a call, a document review, a follow-up meeting. Give them something to hold on to. And when you get in return is the ability to make a strategic decision from a position of clarity rather than reaction. That's almost always worth a week. I've had this come up more than a few times, more than probably I can count, and I'm sure you have as well. A client walks in on a Tuesday and wants a letter out by Thursday. The other side did something. They're furious. They want to put the other party on notice immediately, today, before anything else happens. And I understand that impulse. It feels like action. It feels like control. But there have been situations where sending that letter on Thursday would have been a disaster, where we didn't have the full picture, where a threat we couldn't yet back up would have tipped off the other side, or where the client's own exposure wasn't yet clear and we would have been waving a flag before we understood that what we were walking into. In every one of those situations, the slowdown move, naming what we didn't yet know and why it mattered, was what protected the client. Not from the other side, but from their own urgency. Urgency is not a strategy. Reaction is not a strategy. The slowdown move is how you turn a client's emotional momentum into something that they can actually use. Next slide. Thank you. I want to pause on something before we get into the scenarios. We're going to be walking through the scenarios in a few minutes, because there's a dimension of this work that the framework doesn't fully capture, and I think it matters. Clients who trust you, really trust you, don't just see you as someone who handles their legal problems. They see you as someone who makes them stronger, more capable of facing hard things. They walk into a difficult situation differently because you are in their corner. I hear it all the time in different words. I sleep better at night knowing you're with us. You've heard that. That's not about legal skill exactly. It's about presence. It's about a client knowing that there is someone who understands their situation fully. Not just the legal surface of it, but the history, the stakes, what they're afraid of, what they're capable of, and who is genuinely invested in how this goes for them. That combination of knowledge and care is what makes a client feel like they can handle what's coming. Not because their lawyer promised them a result. And it's really important to distinguish that, but because they don't feel alone in it. I take that very seriously, and I'm sure you do as well. Because if a client feels stronger with you in their corner, that means they're counting on something real. And that's a responsibility worth naming. It doesn't mean you guarantee outcomes. It doesn't mean you absorb their anxiety or become their emotional support system. What it means is that you show up prepared, you communicate honestly, and you make sure they never feel like they're navigating something difficult without someone who truly has their back. Business therapy is part of that relationship and how it gets built. When you understand what a client is actually carrying, all three layers, you become someone they can be honest with. And when they can be honest with you, they can let you actually help them. That's when the relationship stops being transactional and starts being something they value in a completely different way. Not just, my lawyer got me a good result, but my lawyer knows me. And that makes all the difference. That is client control. That helps you do your job well. Okay, next slide, please. 4 scenarios. Let me walk through 4 hypotheticals that show how this plays out across different practice areas. Scenario number 1, the business dispute. Your client is a 50% owner of a small manufacturing company. His business partner of 12 years has started making unilateral decisions, cutting him out of operations, and your client wants to sue for breach of fiduciary duty. Layer 1 is clear. Layer 2, your client is devastated. This was his best friend, or a sibling even. Layer 3, and here's where it gets interesting. As you listen, it becomes clear that your client saw this coming 18 months ago and said nothing because confronting conflict in the business felt impossible to him. The business therapy move is not to ignore the legal claim, maybe a strong one. It's to help your client understand that his avoidance of difficult conversations is what turned a potentially resolvable business disagreement into a lawsuit. Because if he doesn't see that pattern of avoidance, he will recreate it in his next business relationship. How many of you had clients that are serial offenders doing the same thing over and over again? And practically speaking, once the client sees that pattern of avoidance, he may also become more open to a mediated resolution, which might actually give him what he needs: an exit, fair value for his interest, and closure. What I'm noticing as a lawyer in a room, sorry, small detour. Scenario number 2. Your client is a mid-level executive who was terminated. She believes it was pretextual. She had complained about something internally, and 2 months later, she was let go. She wants to file a wrongful termination claim. Layer 1, potential retaliation claim. Layer 2, she feels humiliated. She gave this company 8 years of her life. Layer 3, as she talks, you learn she never documented a single thing. Not the complaint, not the subsequent friction with her manager, not anything. She kept it all in her head because she didn't want to seem like a troublemaker. For those of you who practice employment law out there, I'm sure this is a very common scenario, and you've seen it hundreds of times. The legal challenge is real. The pattern is also real. She downplays her own concerns to avoid conflict and then gets blindsided when the conflict arrives anyway. You can't go back and create documentation, but you can have an honest conversation with her about what her case looks like with the evidence she actually has, what it would cost to litigate, and what a realistic outcome looks like, while also gently communicating the pattern that left her exposed. That's not discouraging her, that's preparing her. When I'm talking to her in that room, what am I noticing? What are you noticing? She's sitting there. She seems competent. She's holding it together. She's using the right words, asking the right questions. But underneath that, she's asking herself, did I do this to myself? Did I make myself invisible for 8 years and then wonder why nobody fought for me? That's not a legal question, but it is the question that's going to determine whether she can make a clear-eyed decision about this case, or whether she's going to litigate to prove something to herself that litigation can't actually prove. Scenario number 3, the estate or real property dispute. Your client is one of 3 siblings fighting over what to do with a piece of property they've inherited. The other 2 siblings want to sell. Your client wants to keep it. It was the family home. She wants your help to block the sale. Layer 1, a partition action or a defensive one, depending on the posture. Layer 2, grief. She's not ready to let go of her parents' house. Layer 3, she hasn't actually talked to her siblings about what this property means to her. She's gone straight to the lawyers. The business therapy move is to slow down and ask her, have you told your brother and sister what this place means to you? Often the answer is no. Often, not always, there is a conversation to be had before there's a lawsuit to be filed. You're not a therapist and you're not a mediator for your own client's family dispute, but you can ask a question that nobody else had asked. And that question sometimes changes everything. So during the intake, what am I noticing when I'm in the room? I'm noticing that she came to me because she needed someone to fight alongside her. And filing a lawsuit felt like fighting. But what she actually needs is permission to grieve. She hasn't gotten that yet. Not from her siblings who want to sell and move on, not from the process, which is already moving toward legal postures. The single most useful thing I might do in the first meeting isn't to explain the partition statute. It's to say, losing this house is a real loss, and I understand why you're not ready. Let's figure out together what you actually need here. Scenario number 4, the HOA or insurance dispute. Your client owns a unit in a condominium complex. Anyone out there who's done insurance lately will relate to this. There's been water intrusion damage, ongoing, significant, affecting his ability to use the property. He's been going back and forth with the HOA for 2 years, Now he wants to sue. Layer one, potential negligence by the HOA, breach of the CC&Rs, possibly bad faith, depending on how the HOA's insurers handled it. Layer two, your client is exhausted and furious. 2 years of this, living it every day. He feels like he's being gaslit, told the problem is minor, when he can see with his own eyes that it isn't. Layer three, as you get into the timeline, you discover he has almost exclusively communicated by phone. There's almost no paper trail. Every time the HOA manager told him something reassuring, he accepted it and stopped pushing because he wanted to believe the problem was going to get resolved without a fight. People don't want to deal with problems. They hope time will solve it. The business therapy move here involves two things. First, you name the documentation problem directly and without blame. He was trying to resolve it cooperatively, which is completely understandable, but it is creative factual record problem you're going to have to work around. Second, you ask the pattern question. Has he been in situations before where he accepted reassurances and waited, and the problem continued to grow? Because the answer to that question tells you a lot about how to counsel him going forward and about what he's going to need from you in terms of active communication and regular updates so he doesn't feel like he's waiting again with no information. Understanding the pattern isn't just therapeutic insight, it's case management intelligence. What am I noticing when I'm in that room with him during the intake? What I'm noticing is that 2 years of being ignored has made him simultaneously desperate for action and deeply skeptical that action will produce anything. He's not just frustrated with the HOA. He's frustrated with himself for waiting. And if I don't name that, it will show up sideways in his representation, in unrealistic expectations about how fast things will move, in frustration when I tell him we need more time to build the record, in calls on Friday afternoons asking if anything has happened. Managing this client well means understanding that his urgency isn't just about the water damage. It's about 2 years of feeling powerless. My job is to give him back a sense of agency, starting in the first meeting. Let's move on to the next slide. The ethical dimension. I want to spend a few minutes on the ethical dimension because I think it's important and because it comes up every time I talk about this. California Rules of Professional Conduct 1.4 requires us to keep clients reasonably informed about the status of a matter and to explain matters to the extent reasonably necessary for the client to make informed decisions. Business therapy, in the sense I've described it today, is simply doing that job well. You can't give someone the information they need to make an informed decision if they're not in a position to receive it. Addressing the emotional layer is a precondition for doing your actual job. Rule 1.2 requires that we abide by the client's decisions concerning the objectives of the representation. Surfacing what the client actually wants, asking, what does winning look like, is how you comply with the rule in substance, not just in form. The client who says, I want to go to trial, without knowing what they're actually seeking, hasn't really made a decision about their objectives yet. They've made a reflexive choice under stress. And Rule 2.1 allows us to refer to moral and ethical considerations as well as law when rendering advice. It explicitly contemplates that sometimes the most useful thing we can do is step back and help the client see the bigger picture. Why am I telling you all this? Because none of what we've been discussing today or what I've been talking about today crosses any professional line. What crosses a line is if you are making decisions for your client rather than helping them make their own. The role here is to ask better questions and listen more carefully, not to become the client's de facto therapist or to substitute your judgment for theirs. I also want to address what happens when you don't do this, because I think the ethical risks of skipping layers 2 and 3 are underappreciated. When you skip the emotional layer and go straight to legal analysis, you risk giving technically correct advice that the client can't act on. Why? Because they're too overwhelmed to process it. That creates a communication breakdown that can lead to misunderstandings about strategy, decisions the client later regrets, and in some cases, grievances or malpractice exposure when the client says, I didn't understand what I was agreeing to. And we've all heard that. When you skip the blind spot entirely, you risk letting the client's unexamined pattern drive the representation. The client who needs to feel powerful may push for aggressive tactics that damage settlement prospects. The client who avoids confrontation may accept a result that doesn't serve their interest just to make the process stop. You've done the legal work correctly, but the outcome doesn't serve the client because you were solving the wrong problem. Addressing all 3 layers isn't just good practice, it's a protection for your client and for you. Done right, business therapy doesn't blur professional lines, it honors them. I want to come back to where I started. To the client, the lawyer, who said what she said that I couldn't stop thinking about. What I've come to believe is that what she identified, you practice business therapy, maybe without fully realizing it, is that the best legal representation has always done this. The lawyers who are remembered, who build practices over decades, who have clients that send their children and their business partners and their colleagues to you, those lawyers have always understood that a client is more than just their legal issues. The framework I've given you today just makes explicit what good lawyers have always done intuitively. 3 layers, 5 tools, and the underlying principle that when you understand what's actually driving a client's situation, you can serve them better, not just legally, but fully. I want to close with something a colleague said to me that I think about alongside that Post-it note. He said, the clients who remember you aren't the ones you won for. They're the ones you understood. Think about that for a second. I know that's right because I lived it actually very recently. I was at a gala a few months ago, kind of event where you run into people from different chapters of your career and your life. And someone came up to me who I hadn't seen in about 15 years, a former client. He had inherited a legal problem from his father, who had passed away, a really hard matter, the kind that arrives already complicated and only gets more so. We went to trial, we fought hard, and we settled for less than what had originally been sought from him. For some reason, I always carried that one. I thought about it more than he probably knew. That feeling of wishing the outcome had been different, wishing I could have done more. He recognized me across the room and came straight over. And before I could say anything, he said, hold on. I want to go get my wife. And he went and found her and brought her back. And then he said, I've thought of you often over the years. I always wanted to thank you for being there alongside us during the toughest times of our lives. You understood us. Not you won for us. Not you got us everything we asked. You understood us. And I'll be honest with you, I often feel the losses harder than my clients do. I replay them, I second guess them. I'm sure you do too. I carry them in a way that probably isn't entirely healthy. That night reminded me that clients are measuring something differently than we are. They're not keeping score the way we keep score. What they remember is whether someone was truly present for them when it mattered. So I want to close with something personal, and I'm sharing it not because I figured it out, but precisely because I haven't. Everything I've described today, the patience, the non-judgment, the willingness to sit with someone in a hard moment and not rush to fix it, we are almost universally better at extending that to our clients than we are at extending it to ourselves. We see clients' blind spot with real clarity. We are considerably less clear-eyed about our own. I carry things. I've always carried things. A matter that didn't go the way I wanted will stay with me long after the client has moved on. I replay it. I overanalyze it. I go back through the decisions, the strategy, moments where I wonder if I could have done something differently. I would have never sit across from someone I say and say to them, let's go back through every decision you made and find the ones that were wrong. You don't do that. That's not how we help people. But somehow it's exactly what we do to ourselves. How many of you out there can relate to that? I'm sure many. When a client replays a loss, we tell them, you did everything right. The outcome wasn't entirely in your control. What matters is how you showed up. When we replay a loss, we hold court on ourselves, prosecutor, defense, and judge all at once. And the verdict is rarely kind. What I'm working on, and I say working on because it's genuinely a practice, not something I've solved, is reminding myself that perfection is not the goal. It was never the goal. For our clients, we understand that intuitively. We know that outcomes depend on facts we didn't create, judges we didn't appoint, opposing counsel we didn't choose, and 1,000 variables outside our control. We counsel our clients around the reality every day. And then we hold ourselves to a standard that ignores it entirely. We are our own harshest critics. I think most of you in this room know exactly what I mean. And I think most of you would agree that if a colleague came to you after a hard loss and described themselves the way you describe yourselves after yours, you'd stop them. You'd push back. You'd say, that's not a fair accounting. So here's what I'd ask you to consider. Just consider. The next time you're in that place, what would you say to a colleague you respected who was sitting where you are right now? And then try to say that to yourself instead. Business therapy is a practice of genuine attention to the person across from you, to what they're carrying, to what they can't see. I believe you deserve that same attention. I'm still learning how to give it to myself, but I think naming it is a start. In closing, we are hired for a legal problem. That is real. It deserves your full attention and your best thinking. But the client sitting across from you is more than their legal problem. They are a person in the middle of something hard, often something they contributed to, often carrying things they have not fully articulated even to themselves. The attorneys who build practices they're proud of, who have clients that come back, that send their families and colleagues, that stop you at a gala 15 years later to introduce you to their wife, those attorneys have learned to meet people where they actually are, not where the complaint says they are, not where the demand letter positions them, where they actually are. That's the whole thing. That's business therapy. Thank you for listening. And we can look, hopefully, at some questions in the chat. So one of the questions is, have you done mediation arbitrations where you shift roles and how? Um, I think I know what that means. I guess shifting roles to a neutral um, would basically just be applying these tools to both sides instead of just one side. And actually, yes, and it does help with bridging the gap between the two sides because as a neutral, what you're trying to do really is, even more than as an advocate, is to understand each side's true end goal. And using these tools to understand and to learn the end goal does definitely facilitate a resolution. And another question is, in our 21st century AI world, aren't more and more clients becoming more and more transactional? So isn't it your practice's goal really becoming more and more rare? All ask kindly, great job. Well, thank you for the compliment. Um, I don't know. I don't know if I completely agree with that. I mean, in a way, it's more transactional, but I think in a way, people are missing the human element even more so than before. Um, people, I think, still need the connection, and people still need to feel understood. And understanding them, I mean, they're in your office because they have an issue, and understanding them is definitely going to be uh, something that you need to solve their problem more expeditiously, more compassionately. Um, so that would be my answer to that, I hope. All right, let's see what else. Um, this one is, do you have any practices that actually help with being kinder to yourself? Or is it just something that you'll live with? Um, Honestly, it's something I'm still working through more than something I've actually solved. I wish I had a tidy answer for you. What I can tell you is that one thing that's helped is to reframe what I mentioned earlier. When I catch myself replaying a loss, I try to ask what I'd ask a colleague that I respect. And that question alone, asked to myself, changes the tone of my internal conversation. It's much harder to be cruel to someone else's effort than it is to be to your own. The other thing I try to remember is that outcomes are not the only measure. And I think that we as attorneys really don't um, don't allow for that. I think we need to be more cognizant of that. Um, if I prepare thoroughly, advise honestly, and stayed present with the client through something hard, that's the job. The result is only partly in my control. Um, all right, there's one more here. Do you find that doing such a deep dive into the emotional drivers of client conduct opens you up to more pain than that is difficult to manage, meaning harder to compartmentalize and be objective? That's a really good question. I don't think so because I think it also allows me to empathize. Um, and I think I already am very I, a little bit maybe overly attached to the outcomes and to the client's needs than maybe is healthy. But I think doing it intentionally and deliberately actually helps with the representation because it does actually achieve better outcomes. So I hope that answers that question. All right. It doesn't look like, oh, here's one more. You haven't talked about what you might want to say to opposing counsel or not say. I spent years working out mutual clients' issues in that manner through my practice over 40 years, allowed for some honesty. You're right, actually. I haven't looked at it from the lens of opposing counsel at all, except for the one really important part, which is, during settlement negotiations, almost every opposing counsel or during settlement negotiations, it always comes up, right? How much client control do you have? Is the client actually going to follow legal advice? Um, not to put our conclusions onto the client. And having that connection with the client, having that trust from the client does allow you to represent to opposing counsel that you do have client control. Because how many times have you heard from opposing counsel that, I will try, but, my client won't listen to me. I don't have any client control. And then you're negotiating with opposing counsel and, they're basically not able to get anywhere with their own client. So just from our side, obviously, uh, engaging in this practice and in it's amazing that you have been for 40 years, will get you the trust of the client, will allow you to have more client control, and will allow you to be able to negotiate on behalf of your client with certainty, with more certainty than someone who doesn't have the client control. Okay, so it looks like we're exactly at 1:31, which is the hour. Really appreciate everyone's attendance. I hope my response to counsel says, oh, it says someone, last person of 40-year practice says, my response to counsel who says he has no control is BS. You shouldn't be representing that client. Fair. That's fair, but how many of them do anyways? Anyways, thank you again, and I hope to see you see you out there, and I hope everyone has a great rest of the day. Thank you so much.
This concludes today's presentation. Thank you so much, Talin, for an excellent presentation today, and thank you so much to our audience. Have a great day, everybody.